Thank you.
Recording the screen and video.
Whether my screen is visible?
Yes, sir. Yes, sir. The screen is visible.
So can we start the session?
No, sir. I'll be giving introduction and then I'll hand over the session to you, sir. Thank you. Good evening, all. Over the past few days, this FTP has taken us through the journey of research, from shaping ideas and framing strong questions to writing, publishing, and understanding ethics. Today, we arrive at a crucial turning point in that journey, where research moves beyond papers and enters the real world. Welcome to the day 5 of 6 days faculty development program on From Idea to Impact, research paper writing, publication, and patent filing, organized by Department of Electronics and Communication Engineering in association with Research and Development Cell of the Academy of Science and Technology, Technical Campus, Kilimanur. Today's invited session on patent filing and research commercialization focuses on transforming research outcomes into protected intellectual property and market-relevant innovations. This session will help us to understand how ideas can be safeguarded, translated to patents, and eventually converted into technologies that create real societal and industrial impact. It is my privilege to introduce Dr. Anandan D. Thambi, Project Lead at MED, National Institute of Technology, Calicut. Dr. Anandan Thambi has strong academic and research credentials with a doctoral background in mechanical engineering and hands-on experience in industry-relevant and government-funded research projects. He has actively contributed to innovation-driven research, patent development, and technology-oriented projects, including national initiatives in advanced engineering and applied research. With his experience in research execution, patent filing process, and commercialization pathways, Dr. Anandan brings a practical and application-oriented perspective that is extremely valuable for faculty members and researchers aiming to move their work from lab to real-world deployment. We are confident that today's session will provide clear insights into protecting research ideas, understanding the patent ecosystem, and exploring avenues of commercialization. I now invite Dr. Anandan D. Thambi to take over the session. Sir, the session is yours. Thank you.
Thank you. We will directly go into the topic. Today's topic, we are planning to take patent filing and its research commercialization in India. So first of all, directly going into patent, I would like to introduce you about the basic. So we will start from that. So an intellectual property right, that is IPR, is just a legal right where the inventor will be given protection over this invention or creation for a certain period of time. It won't be for the lifetime. It will be only just for the short period of time. So mainly it can be classified into two types. One is the copyright. Second one is the industrial property. So copyright is actually mainly focused on artistic works, like cinematography, music, and other literary arts. And when it is coming to industrial property, it is mainly divided as trademarking and geographical indications, and also patents, industrial design, and trade secrets. So coming to the copyright, I have already mentioned it is just a monopoly right that is given to the creator or an author who has done his literary work or the artistic work or the cinematic work. So coming to the technical aspect, actually copyright we can see it mainly in computer programs, books, and also research articles, databases, drawing, and also work of architecture. So C with a round circle. Whatever you're seeing is actually a symbol that is given for a copyrighted data. And in most of the books and all, you will be seeing this copyright, all rights reserved. So I would like to have a question whether now most of you, since this is a faculty development program, most of you will be faculties and also research scholars. So now I have published a journal. So I have certain contents in my journal, and also I'm having a photography or a picture or let it be a figure explaining something. Whether do you have the right to use the same figure in your journal? Could somebody answer that? Even you can put a message in the group, in the meeting, whether that can be, whether that is an acceptable thing. From a journal that I have published, whether can you copy paste the same figure into your journal? Okay, nobody's answering, so I will continue then with my answer itself.
No, sir.
Okay, okay. So the answer is actually when you are publishing a journal, the authors are supposed to give a copyright agreement to the concerned publisher. So the publisher will be having all the rights related to the works that are getting published. So in the case of a journal that I have already published, if you want to take a figure from that journal, you need to take rights and permission actually from the publisher before taking it and copying it into your paper. Then coming to the trademarks, in the case of trademark, it can be anything. It can be a word, a phrase, symbol, design, or it can be a combination of all these, which can identify either the goods or services. So, we all know that this symbol M, that is actually for McDonald's, because it is actually a registered trademark. So now here beside this M, you can see an R with a round circle. That defines that it is already registered. Nobody can use that other than McDonald's. Similarly, in the left side figure also I have shown one round with the TM and SM. TM is actually trademark and SM is actually service mark. So TM can be kept with the companies that are they are trading a product. So Nike, Coca-Cola, Puma, etc. These type of people are having some products. So they are given TM because once you are registering, you are filing an application for registering your word, phrase or symbol. Initial stage you can only give TM, but once it is registered, you can give R with a round circle. Similarly, in the case of SM, it is actually service marking. So it can be like Uber, Google, Facebook. These people are actually service providers. Similarly, for fruiting, if you are saying it is fresh and juicy, that is actually the tagline that is given for fruiting. Similarly, for Amul, it is like Taste of India. So these type of things can't be copied by anyone else if it is registered under trademark. Next is coming into geographical indication. This is actually just to identify a product which possesses certain quality and characteristics that are originated from a specific geographical area. So from India, each places are having their own geographical indication tagged products. Actually, 600 plus registered GA products are there in India, and 31 registered products are there from Kerala. Like from our Kerala, mostly everybody will be knowing about Adamula Kannadi, which is one of the registered GA products in Kerala. Now coming to the industrial design. So this is actually an idea that is used to protect the visual design of an object. Now in this photo, what I have shown is a Volkswagen Beetle. So Volkswagen has actually done the industrial design IPR. So this shape can't be copy pasted by anyone else. So it can be not only just 3D aspect. Like what I have mentioned is only 3D aspect, that is the shape. Similarly, in the case of 2D aspect also, patterns, color, combinations, such things can also be listed into industrial design. Next is trade secret. That is information that can be kept as a trade secret for their business. It can be either a formula or a program or a methodology that is being followed by them. So like some of the examples are like KFC's original recipe for the crispy chicken, then Google search engine algorithm, and also like McDonald's Big Mac special sauces. So these type of things are being considered under the trade secret. Now coming into our aspect, that is the patent. Patent is actually an exclusive right that is granted for an invention or the creation. It can either be a product or it can either be a process, but it should be a technical invention. So some of the examples are like light bulb. Thomas Alva Edison, like he developed this in 1978, and I'm showing just a figure of an old patent journal that has been published related to the light bulb finding. Similarly, IC engines, different types of IC engines were founded, and also telephone. These are all like patented items. Now, the main thing is why I should patent my idea. Since like I am having an idea, and from idea, first it should be made into a prototype, then a product should be developed with the proper testing. Finally, after market survey, it should be coming out into the market as a product. So why I should patent my idea is a very important thing. First thing is actually it's exclusive right. The thing is your idea will be protected for about 20 years as per the Patent Act. And also you will be getting a lot of economic benefits also. Like the owners can gain like monetary benefits from the invention either by licensing or they can sell the item on their own. Then comes the limits. It also limits the competition. The thing is, once I am patenting my idea, nobody will be able to copy my innovation. So they need my approval. That is like I need to give a license to them that this idea can be implemented by them. For this, it attracts investors. So like if I'm having an idea, like I'm explaining my idea to everyone, means they won't be interested in investing any money into my idea. But if I am having an idea that is getting patented, people will think like, okay, there is something novel and inventive steps are there. So automatically investors will get attracted to this type of ideas that are being patented. Now, coming to the point, like what can be patented and what not can be patented. So actually, patenting is actually not only just a technical thing, it is actually a legal procedure. So as per Patent Act 1970, under the Indian law, like what all can be patented and what all can't be patented has been clearly mentioned. So if you are going to US, like in the case of Indian law, we can only publish like product patent and process patent. But if you are going to US, lot of other patents can be done, like design patent can be done, and also plant variety patenting can be done. Lot of things can be done. So in India, primarily, patenting types are product patent and process patent. So in the case of product patent, actually the final product will be fully protected once you are having a patent. But it prevents others from making, using and selling that specific product. Whereas in the case of process patent, actually the product is not at all protected. Only the method or the process used for manufacturing that product is getting protected. So if somebody wants to, like in the case of a pharmaceutical drug, if I am developing a pharmaceutical drug in a certain way, like let it be A. So if somebody wants to create the same drug using a different method called B, it can be patented. So process patenting means it is not about product, it is only just about the method or process that are used for manufacturing the product. Then related to IPR, there are separate acts also. Like I already mentioned, like US and all, they are already having patent for design patenting and plant patenting. But in the case of our country, these are not considered as patent. They are considered under different, like protection will be given under different acts. So under Design Act 2000, industrial designs like shape, pattern, color, such things can be patented and we will get a protection of up to 10 years. Usually in the case of patent, we will get a patent protection up to 20 years, but in the case of industrial designs, you will get a protection up to 10 years and it can be extended by 5 years also. And in the case of plant varieties, India does not grant actually plant patenting. Instead, new plant varieties will be protected under Protection of Plant Varieties and Farmers' Right Act 2001. Now, what are the items that can be considered as an invention, that can be patented? So actually, there are two sections under the Indian Patent Act. One is Section 3 and another one is Section 4. So under Section 3, a few items are coming here that I would like to explain. So anything that is contrary to the well-established natural laws. So now, as per Newton's gravity law, whatever that we are throwing up, it should come down. So if you are trying to find a new thing like whatever I am throwing, it will go up. It is actually contrary to whatever natural laws we are having. So such type of inventions can't be considered. Second is finding something that already exists in nature. Whatever that is existing in nature, that is actually not considered as an invention. It is only just a discovery. Then the third thing is a form of a known substance, unless it shows a significant enhancement in efficiency. So if you are finding a known substance in a new form, like now our water is having different forms, ice, vapor, like that. If you are finding a new form for that, it should have a significant enhancement in some property or efficiency. Then the fourth thing is a simple mixture where components just do what they normally do is not patentable. Actually, if I am having a combination which is having two components A and B, so if A has a property to give me better property on certain aspect, and B has a property on certain other aspect, if these properties are getting synergetic effect only, it can be patented. Or just randomly A and B I am adding and I am getting the properties of both A and B in C means it won't be patented. But if the property of the final mix is better compared to both means due to synergy effect, it can be considered as an invention. Then next point is putting two existing machines together without a new functional relation. So now if I am having a tank and I am having a stirrer, if I am simply adding both these as a combination, it won't be considered as an invention since it does not have a new functional relationship. And you can't patent something that is already in our local knowledge and traditional knowledge. Then coming to section 4, section 4 also deals with invention that can't be patented. It mainly deals with the compounds that are related to atomic energy, like uranium, beryllium, thorium, like plutonium. These type of things, if you are coming in with some invention related to these items, it is actually related to atomic energy. So mostly Indian government won't be giving you permission for that. And also any invention that is going to cause damage to human, animal or plant life or health or environment. Then coming to the next thing, is my idea patentable? So actually there are 3 factors that need to be considered for your idea to get patented. And throughout your patent procedure, all these factors like novelty, inventive steps, and industrial application will be considered, and queries will be coming to you from the patent office regarding this aspect. So novelty, what is novelty actually? So novelty is actually an invention that is not published not only in India, anywhere. It should be actually a new thing that is being performed. Next is inventive step. Inventive step must not be like obvious to a person skilled in this art. Like it should if you are following a process that is followed by a skilled person in this field of invention, it won't be considered as an inventive step. Third one is the industrial application. So whether your invention has the capability to be used in any kind of industry will be also be checked. So these are the 3 parameters that you need to think when you are planning to patent your idea. So coming to the patent filing procedure, this is actually a flowchart that will show you an end-to-end procedure from idea to filing a patent. So this is actually like a life cycle of an Indian patent. So I will just brief you first, then I will go deep into each steps. So first step 1 is actually pre-filing check. Pre-filing check actually, some people will say it is like an optional thing, but I suggest you it is a mandatory thing to be checked. Because before disclosing your invention, you need to check all the 3 parameters that I already mentioned: novelty, industrial application, and inventive step. And this should be clearly checked because otherwise, after filing your patent, you need to file government pieces will be there, other professional pieces will be there for the agents. All this, if you are filing an examination stage, if it is getting rejected because of these parameters, like unnecessary like money will be lost. So it will be better to do a pre-filing check first. Second is drafting. Like once you have an idea, you need to write about your idea properly, what your claims are. Like it should be like a proper abstract should be there, what you are going to claim, what are the specifications that you are expecting, including drawings, figures, everything should be made properly. And drafting can be done in properly, that I will explain you in the next slide. Coming to the step 3 is filing. Once drafting and pre-final check is done, first you need to file an application for submitting your patent along with some other forms. So specifically form 1, 2, 3 and 5 need to be submitted to the e-filing portion. So along with this, you need to pay a fee, government fees also. And then comes step 4. So once you are completing step 3, actually on the date when you are submitting your application for patent filing, your date will be considered as a priority date. So from that date onwards, if the patent is getting approved, you will get the rights from that date. So that is considered as priority date. Then coming to step 4 is the publication. Actually here, once you are filing the application patent office, they have an Indian Patent Office journal. There they will be publishing all the details that you have given to them. So from then onwards, it will be like a public domain for everyone. So step 4 should be completed. Usually it will be automatically completed within 18 months. And if you want, you can give a request and it will be published earlier also. So once you are completing the step 4, actually it is a public domain knowledge and anybody can look into it. From there onwards, like if I am comparing, if I made a lubricant and I'm comparing with some company product, I'm saying that my company product is better, means if that company people are seeing this patent, definitely they may come for an objection. So from patent for anybody from India or outside can object your patent whether it is similar to the above or like regarding your research and all. So before like by doing your application, everything should be properly completed. If there is experimentation, everything result, everything should be properly mentioned in the application step. Now coming to step 5. Step 5 is examination request. So once publication is over, objections will come. After that, within 48 months, actually before March 2024, the time required for the examination request was 48 months, minimum 48 months. Now they have reduced it to 31 months. So in this case, actually for step 5, you need to file a form 18 or 18A where you can request for examining your finding. So the thing is, they won't be actually checking into your product whether it is functioning properly or not. They will be only checking into your results and the write-ups what you have given. They will be comparing it with the patents from India and outside India. And they will suggest you whether the patenting that you have done is novel or inventive at that time. That will come in step 6 prosecution. So they will give you a first examination report on these aspects, which I have mentioned that you need to check in the pre-filing check. So once you are getting this first examination report, you need to give a proper response within 6 months. And then comes the steps 7. So this is actually like a legal code. Once you are giving your answers, there will be hearing where you or your agent should go and explain about the novelty, inventory procedures and all the objections they are having. So once these objections are overruled, means step 7 will be coming into granting, where your patent will get accepted and you will be granted a patent and also certificates will be issued to you. And mostly once your patent is granted, you will be getting a certificate where only applicant name will be there. So applicant usually will be a company or your institute. So like the inventor's detail and everything will be only available after publication. Once you are filing in step 3 and completing your application procedure, you will get a document where along with the applicant, all the details, inventor details, everything will be there, which can be shown as a proof for your patent. Then comes step 8. Step 8 is actually maintenance, where actually even though your grant is for 20 years, for the first 2 years, you don't need to pay any renewal form. But renewal fees won't be there. But after that, for the third year onwards, you may need to provide a renewal fees. So you can either pay together or every year there's a certain amount that need to be paid. So once this step 8 is over, means your patent is fully with you, and after getting your patent granted, there will be a 1 year period where anyone can object your patent, whether your finding is correct or not. Anything can be objected by anyone only up to 1 year. Once this 1 year is over, means there won't be any issue, any objection in your patent that has been granted. So coming to the first step, that is pre-filing check. The main thing that we need to do is the patentability check. So first thing is novelty, inventory steps. Third one is industrial application. So all these three need to be checked. So you can use actually some databases are there in some websites related to Indian patents. So it is like InPass, what I have mentioned here. There you can do the novelty check, whether this work was previously published by anyone or any similar work is there. What are the difference in that work compared to the already published work? Those things should be properly examined before doing the drafting. So first step should be mandatorily done, even though most people are saying it is like an optional thing, but it should be done. Now, second is drafting. So I have already mentioned drafting can be done as like two different ways of drafting can be done. Either professional drafting, that is where like we need to make the specifications like drawing, claims, everything will be in a preliminary stage. So it is only just like an idea patenting. Or you can go with the complete specification. That is like an ordinary application where all the details, not only just your idea, you have implemented the prototype, done the testing, everything will be there. So both ways of application can be given, either professional application or ordinary application with complete specification. So if you are going with the professional specification one, once you are filing within 12 months, you need to submit your completed specification. And if you're having an idea and you need to do some work, so if you are so sure that your idea can hit the market, means better you can go with your idea patentation, because once your professional specification is being applied, you will secure a priority date. So from the date of application, you will get a legal protection for your finding. Even though it is just an idea, after that you can develop your idea and make it into a complete prototype. Now the third one is filing procedure. So first we need to submit form 1, that is application form, along with form 2, that is specification. In this specification, actually, what all things you are planning to claim, what are the main findings, all these claims should be clearly drafted, and also results, figures, all the drawings related to your patent and product should be mentioned. Whether it will be a process patent or a product patent, all the details that should be provided. Otherwise, like inventive steps will be lacking. So you can file this IPO via an e-filing portal, or you can go in person to patent office and submit also. So I think you guys know patent office is actually available in 4 places. One is in Mumbai, then Chennai, Kolkata, and also in Delhi. So coming to form 3, like along form 1 and 2, 3, 5, and 28 are also mandatory. Form 3 is actually a statement and undertaking for foreign applicants. And form 5 is actually declaration of inventorship. It is actually required only with the complete specification. Then form 20 is actually mandatory for startups and small entities. Because small entities and startups, they will get a patent fee concession of about 80%. So form 20 also need to be submitted along with these forms for filing. Next is coming into the publication. So this is actually not the ordinary journal publication that we used to do in academics. Once the invention is applied for patent, in the Indian Patent Office, they have a book of journal where inventions will be published. So automatically after 18 months, it will be published, or else you need to fill a form 9 for requesting for an early publication. So Form 9, if you are planning for early publication, you need to file it at least 1 month before the patent filing. Next is request for examination. It is mentioned that RFE. So Form 18 should be submitted within 31. Like I already told you before, like it was actually 48 months before the till 14/3/2024. From 15/3/2024, they have reduced that 48 months into 31 months. So even now also some confusions are there. So what I have understood is actually either 31 months or 48 months. Before that, it should be done. As per the current rule, it is actually 31 months. So these type of deadlines that they are providing should be properly followed. So it should not be delayed. And there is another form also, Form 18A. It is actually for expedited examination. So before, like, no need of waiting for 31 months also, before also, small entities, startups, and also applicants with at least one female applicants can apply for examination under Form 18A. So the RFE can be done a little bit more earlier. So you might have seen in some applications where female candidates are also there, the patent is getting granted very fast. So this is actually one reason for that. Then the sixth is examination. This is where the examiner issues an first information report with all the objections. I think if you have written journal publications like paper publication, mostly the reviewer will be giving you comments like why your results came like this, you need to give a reason. That publication. But here in the patent publication, they won't be focusing on that. They will be over their application and they will compare all your works with the previous publication. And even if you not only this publication, also with the patent. And even if you have published any work related to this before, that also may come as an objection in the FER. So as a seventh step, you need to respond to all these objections. So addressers examination report need to be carefully studied and each thing should be answered with the proper feedback by comparing what are the previous works that has been done. And this should be completed within a time period of 6 months. And using Form 3, you can file for an extension for at least 3 months. That is the maximum extension that will be available. So once all the options are granted, automatically the granting will be done and your patent will be granted for 20 years and it will be published in the patent journal. So the ninth step is for maintenance, that is for keeping your patent active for 20 years, you need to pay an annual renewal fee, which is starting from 3rd year. Now, coming to the government fees for filing an Indian patent. Actually, for filing Indian patent, government fees are comparatively low compared to its professional fees that we are paying for a patent agent. So the amount that I am showing here is mainly for small entities and also for individuals and also for startups. Whereas in the case of if it is a large entity or a very big company, they need to pay 5 times of the amount that I am showing here. And from the values also, I think it is understandable. If you are going for an e-filing, fees is less. If you are going in hand, your fees will be like about 10% higher compared to e-filing. So in the first stage application filing, you need to pay an amount of rupees 1,600. If you are going in person means it will be 1,760. And for early publication, I have already mentioned Form 9 should be filled. Along with Form 9, you need to pay an amount of 2,500. So in person, if you are handling, it will be 2,750. So most people are doing e-filing only since everything is available online. And next is the request for examination, which is coming as Form 18. Once you are filing your Form 18, you need to pay an amount of rupees 4,000. If you need to speed up your examination and if you are having a female applicant or if you are a startup or something, you can file Form 18A. For that, you need to file it, pay an amount of 8,000 rupees. These amounts are actually for 30 pages. Actually, patented, once you are writing the patent as per the template given, it should be within 30 pages, and also only 10 claims you can claim under this patent for under this amount. So beyond this, also there won't be an issue, but you need to pay extra amount. It will be like 160 per extra page, and also 320 rupees per extra claim. And also, I have already mentioned for maintenance, you need to pay an annual maintenance or renewal fee. So it will be starting from third year. So for third year to sixth year, it will be 800 rupees per year. And from seventh year to 10th year, it will be 2,400 per year. And from year 11 to 15, it will be 4,800 per year. And remaining 16 to 20 years, it will be 8,000 per year. Either you can pay it annually, or you can pay it as a whole amount for the 20 years when you are getting your grant. So if I am considering in an ordinary procedure, if you want to file the Indian patent, the government paid fees that you need to pay is actually application fee of 1,600 and the request for examination 4,000. So 5,600 will be the government fee that you need to pay. Next is coming into professional fee for filing an Indian patent. This is mainly for hiring a patent agent. So coming into the patentability search, people are charging from 5,000 to 25,000. And for drafting, like professional specification and claims, they will charge you up to 5,000 to 30,000. And drafting and filing complete specification, they may ask you 12,000 to 50,000. Then once you are filing your request for examination, they will consider you for the fees of 2,000 to 10,000. Finally, for response to examination, there will be a lot of objections from, an amount of 10,000 to 60,000 will be asked for that. And for each hearing, an amount of 10,000 or to 20,000 will be asked for each hearing. Then maintenance and renewal support, it will come from 1,000 to 10,000 per year. So for an individual researcher or a startup person, if you need to file an Indian patent, the professional fees may come from 40,000 to 1,50,000. So instead of this, now lot of patenting agents are there. Some people are having like packages like filing to grant for an amount of 65,000. So this is actually without the government, it's only just the professional fees. So once we are considering all this amount, it may go up to 1.5 lakhs. So these packages can also be considered. And also for academic purposes, like for patent purpose for students and academic students, some discounted academic rates are also provided by agents from patent search, drafting and filing till the last end. They will only charge you up to 10,000 to 27,000. So I think most of the institutes now, they are having a tie-up for IPR. So those companies will be giving you a very discounted rate so that students and academicians can do the filing of their patent in a very small amount. And even state government also under KSCST, actually there is an IPR section where they are having a tie-up with some IPR companies, and they are also providing all the assistance required for academicians and also students. So that can also be considered if you don't have a IPR team with your institute. So this is actually a question I would like to ask, because once I am seeing the professional fees, it is coming up to 1.5x. Can I file a patent alone without any agent? Like, can anybody answer this? Can you put a message in the meeting?
Participants can type their answers in the chat box.
Okay. Okay. So yeah, like it is somebody mentioned that yes, actually she has mentioned as yes. Okay, can I file a patent alone without an agent? Actually, the answer is correct. It is yes only. An individual can file a patent alone. As I already mentioned, under the Indian Patent Act 1970, an inventor or an assignee is fully authorized to file a prosecute their own application. but there are certain pros and cons. I already mentioned that patent is not just a technical file, it is a technical and legal file. So the pros are actually we can save a lot of money. This professional cost of like about 1 lakh can be fully avoided. Second is we will be having a direct contact. We will be managing all the correspondence, filing everything through e-filing portal. So we will be fully updated with all the aspects. Coming to the cons and also risk of filing, once you are drafting your specification and claims, it should be very precise, such that we should get a patent, and it should not be overruled by anyone else. So, patent is actually a techno-legal document, and if you are poorly drafting the claims, it will be an easy task for your competitors to design a better thing compared to yours. Maybe your product may be better, but if you are not able to draft your specifications properly, the same thing or a better thing can actually be redrafted by a competitor of you with a new product and can be easily patented. So, like if the draft, you should strongly consider that your drafting should be very proper so that your patent should be granted and no one else should be able to take your design over. Second is procedural deadlines. Actually, I have told you a lot of within this many months this should be done. Each procedure is having a certain deadlines. This should be properly and strictly followed. If you are unfortunately forgetting a deadline, your application will be abandoned. Third one is examination timing. So once the first examination is reported received, there will be a hearing where you need to explain your things, and it should be as per the patent laws. So you should be having a deep knowledge of patent law, and also prior art knowledge should be there. If you are non-professionally, and if you are not a professional, it will be difficult for you to argue there at that time. It is actually like a courtroom. So anyway, the answer is yes only. Any individual can file a patent alone. That is possible. Next one is most of the people will be having a doubt whether my Indian patent will get a worldwide protection. I have patented my work in India, so whether I will get my patent will be protected worldwide. Can anybody answer this? Okay, no answers coming, so I will continue. So the thing is actually, once I am patenting my idea of a full product in India, means I will only have my protection within the boundaries of India. Okay, so the answer is no. An Indian patent does not provide worldwide protection. All the patents, not only India, if you are going and patenting in US patent also, the patent that you are getting is only a territorial patent. The protection will only be within that specific country. So in case of India, we have different types of patenting applications. First one is professional application. This is actually temporary filing where your idea can be patented, that I already mentioned. Second is ordinary application, which is a standard application where you are filing the patent with the full details. Next, the third one is actually conventional application. So if instead of filing a patent in India, I can actually go and patent a file outside India also, in any other country. But before that, you need to take a permission from Indian Patent Office. So after filing a patent outside India, you can come and file a patent inside India also. That is called a conventional application. So once you are filing a patent, you will get a priority consideration up to 12 months. So next is PCT, that is Patent Cooperation Treaty Application. So this will actually give you a worldwide protection for a certain period of time. It's actually an international application which includes PCT International and PCT National phase filing for broader global protection. So now to protect your research globally, you can either follow two methods are there. There are specific international route maps that can be followed by you so that you can protect your patent. So first one is the critical foreign filing license. That is FFL. So I already mentioned about the convention application. So if you want to file a patent outside India, first you need to get a permission from India. Or else the second thing is you can file a patent first in India. So as an Indian resident under section 39 of